high-capacity crowd, Ms. Roper, for something that is agreed.
Yes, yes, my lord, my lords and my lady. I don't think I've ever seen a courtroom.
Yes. No, it's a pleasure to see everybody. We've been discussing how we might proceed. But first things first, there's a need for a reporting restrictions order, and we're grateful to Ms. Harris, who's forwarded a draft. Obviously, we're content to make a reporting restriction order. One point that we spotted was that in paragraph 3, there's a list of the matters that are to be prohibited from identification, and that includes the local authority. As paragraph 5 says what's not included in this order, and C says the local authority. So, which is it?
I'm grateful, my lord, and we've had some discussions about that. That order has been both served on copy direct, and we have discussed it with the member of the Press Association who's here today. It was proposed in the original draft that the local authority was named. The local authority had some concerns about that because it's a very small local authority, but they are named in paragraph 2 of the judgment in the published version on Rayleigh, and so the local authority accepts that it should be named.
Right.
So 3E
can
now be removed.
Yep. Yes.
And I'm sorry, I don't have another hard copy, but I will send in a version with 3E removed and 5 will therefore be.
Right. So for the avoidance of doubt, if my lady and my lord agree, we'll make a reporting restriction order which will prohibit anything that might identify the appellant child or the child's parents or any persons or organisation caring for the child, or the social worker and guardian who've taken part in the proceedings, and the individuals mentioned in Schedule 1, which are the same people who are the individuals connected with the case. That order is effective from now. This case is being live streamed, and the order applies to anybody on the live stream as much as it does to anybody else. But the order won't restrict publication otherwise of the issues in the case and the process of these proceedings.
I'm very grateful, my lord. It's not anticipated that we're likely to be referring to any names or details which aren't in the judgment.
No.
But certainly we're very grateful for the reporting restrictions order.
We're extremely grateful to everybody for their skeleton arguments, and that includes obviously the interveners who've contributed. There's obviously a high measure of agreement. I don't know whether you've had a discussion with the bar as to how you thought it might be most useful to proceed this morning.
Well, we've had some discussion. Would it help if I just went through who is here, or are you happy?
I think that would be helpful. That should certainly take some time.
Yes, well, I'm conscious that I've got an hour, and if I talk slowly, that may be probably be at the end of it. But I will try and go briefly on that. I appear in this matter instructed by the children's guardian, who sits with me here, Mr. Plummer,
yes.
And my junior, Ms. Harris.
Yes.
The first respondent, Bath and North East Somerset Council, is represented by Ms. Kavanagh,
yes.
King's Council, and by Ms. Zabihi,
yes.
behind her. And they have with them the instructing solicitor, Rachel O'Sullivan, and a mini pupil, Prova Gerda.
Very good.
The second respondent, you will be aware that Ms. Butler-Cole, who has contributed to or filed the skeleton argument, has not attended largely for reasons of saving public funds, but her junior is here, Ms. Smith-Holland, with her instructing solicitor, Sophie Webb, and a pupil, Tom Swain.
Good.
The third respondent, similarly Mr. Nick Goodwin, whose name is on the skeleton argument, is not here, but Ms. Sorrel Dixon is with her instructing solicitor, Amaya Hampson.
Yes.
The first intervener is represented by Mr. Ruck Keane, King's Council, Miss Ariana Kelly, and Miss Eleanor Layden, and they have with them here Caroline Willow and Alice Livermore, both of whom have filed witness statements,
Right.
which we have in the bundle.
Thank you.
The second intervener, the Children's Commissioner, is represented by Mr Broach, Mr Thorold and Mr Carvalho. They also have Anna Moody, who is a pupil with them, their instructing solicitor, Sophie Wells, and Beatrice Longmore. Again, you have a witness statement from her.
Yes.
She is from the Office of the Children's Commissioner. Last but not least, the Secretary of State for Education is represented
Yes.
by Ms Clement and Mr Willis, and they have with them Joe Vester, the Solicitor for the Secretary of State, and Emily Bigham from the Department of Education.
Oh, well, that's very helpful.
I think that is now everybody.
Good.
We have had some discussion. We are, of course, very much in your hands as to how much detail you would like. I had assumed that, not least for the benefit of anyone watching this, you would wish to have some general introduction.
I think it would be.
to the case.
I think that would be the proper thing to do. Obviously, the hearing was listed and it carries on, and we were content with that. But that was before the time when all three of us had immersed ourselves into the skeleton. So the level of agreement is now obviously apparent to us, and there's no need to rehearse all of the arguments. It does, on the papers, appear that there's the potential for some dispute between the local authority and I think the Secretary of State over it. I think it may be paragraph 62 of your skeleton. So it would be helpful to understand from you whether your position remains as it was or whether you've had further cause for thought seeing those later documents.
Would you like me to deal with that now?
It'd be helpful
Or
to
shall I
flag that
start
up.
with you?
Well, why don't you open the case in short but clear terms so that anyone watching or attending who doesn't know about it can hear about it, and then we'll move to the detail after that. Otherwise, it won't make any sense.
I'm grateful, my lord. That's what I'll do. So, this is an appeal against the judgment of Mrs Justice Lieven, which was handed down on the 25th of June last year, following a hearing which took place on the 1st of March.
Can I, having said get on with it, I'm interrupting. At the hearing, and it may be that those behind you, Ms Sabihi and others, will know this, was any party raising the issue with the judge and saying this isn't a case for dolls, or was it a matter that the judge perfectly legitimately questioned herself?
It was a matter which I will be corrected from behind if I'm wrong, but having read the skeleton arguments and had some discussion about what took place at the hearing, my understanding is that the position of all the parties, certainly on paper, was that this was that Jay was the arrangements for Jay's care had the effect that he was deprived of his liberty. I think for completeness, the local authority skeleton said may, but I don't think anything turns on that. The position was that the court's authorisation was required for that. And my understanding is that this was a query which Mrs Justice Lieven raised herself and asked for submissions on at the hearing. And
So it didn't go off for further submissions. It was the advocates had to deal with it on the day.
yes, well, the advocates had it had previously been before Her Honour Judge Barlow, who had referred it on to Mrs Justice Lieven. So they had filed short skeletons saying why they considered that that the court's authorisation was required. Right. What didn't happen was that Mrs Justice Lieven's reasoning wasn't obviously set out until they got the judgment, and so they didn't have an opportunity in writing to engage with that. I think that's I'm so sorry. Can I turn my back for a minute just to make sure I'm not misrepresenting? No, I'm told that is right.
Yes. And so I haven't myself gone back to look at the skeleton arguments that were put in front of the judge, but is it right to assume that the case that is, as it's now set out before us, in terms of the arguments that are raised, wasn't put to the judge with the same clarity or indeed the same content?
It may not have been put with the same, it certainly wasn't put with the same detail.
That's not to be critical of anybody on the day. We'd have all been...
No, I think it's fair to say it was not put with the same detail as it has now been. It was not put before the judge with the same breadth. And although some of the cases that have now been cited to your Lord, to this court, were cited to Mrs Justice Lieven, in particular, certainly the judgments that you've been referred to, Mr Justice Keir.
Yes, obviously.
And the judgment of Mr Justice Mumby, as he then was in Re AF, those were cited, and as was Re D.
No.
But I think Re T, which the local authorities skeleton addresses in some detail, I think that was not cited.
No, well, that's helpful, and I don't think we need to go into the post-mortem about what happened, but it just gives us the shape of the way matters proceeded.
Yes, I hope that helps, and certainly I gather I'm not misrepresenting the position.
Thank you.
So the application concerns, and this appeal concerns a child who is known as Jay. He was, at the date of the judgment, 14 years old. He is a child with complex needs. He has autism, ADHD. He has pica, which is a condition which leads him to try and eat non-food items. He's non-verbal. He understands a routine, but his needs are very much higher than those of most 14-year-olds. Those needs must be met to keep him safe and well. And his conditions are lifelong. While they can be managed, he is likely to have a similar level of need throughout his life. And the disparity between the restrictions placed on him now and those typically placed on a young man of the same age will therefore only increase as he gets older. Jay's parents, for very understandable reasons, struggle to provide him with the level of care which he needs. I won't go into the details, but the outcome is that he now lives in a specialist children's home, which is registered with Ofsted. It's important to recall that there's no dispute about the quality of the care which Jay receives there at this stage.
And he's been there for quite some time.
He had been there for quite some time when the application was made. And the reason for the application, the trigger, was essentially that the local authority also applied for a care order. And they did so because there had been some difficulties in contacting Jay's parents at times when there was quite an urgent need to do so. There were concerns about the extent to which they were able to exercise parental responsibility, and so the local authority made that application.
And so, in legal terms, am I right that the regime in the children's home, insofar as it deprived him of his liberty, had been in place for some time, but it was being operated on the basis that there was parental consent, he being a young person under 16 who lacks civic competence?
Yes, my lord, that's certainly my understanding.
And so, as you've said, local authorities decided that they needed parental responsibility alongside the parents because of the occasions when there was a need for someone to consent to something and the parents were, for whatever reason, not in contact.
Yes. Yes, my lord. That's exactly it. And those restrictions for completeness are set out in the judgment, and they are that the windows in his room have latches which can only be opened about an inch. He's completely supervised when he's in the community. If he wants to go in the garden, he has to take his shoes he does take his shoes to the door, but then when he goes into the garden, he has to be fully supervised, and he has to be followed to the toilet. The property is, as it is, of course, as it has to be. It is pica safe. All small objects that he might otherwise try to eat have to be placed safely away from him. And at night there are 2 working staff supporting Jay and the other 2 children in the property. In addition, he has to wear a harness if he travels in the car. So those are quite severe restrictions, albeit that they are entirely appropriate to keep him safe. So the local authority brought its application for a care order and shortly afterwards brought an application under the inherent jurisdiction to authorise the deprivation of Jay's liberty at the placement. And on the 1st of March, Mrs Justice Lieven considered the skeleton arguments, there was no opposition to the care order being made. So she made that on the 1st of March. She granted an interim authorisation for the deprivation of Jay's liberty pending judgment, and then she handed down judgment on the 24th of June.
And pending this appeal, has the interim authorisation carried on?
No, my lord.
So on the basis of her judgment, she said
Yes.
there'll be no authorisation. So on what basis has the regime, which presumably has carried on and been in place, being undertaken?
Well,
as it was?
The regime has carried on as it was. It was, of course, agreed that it was in his best interests.
Yes.
And for the reassurance of the local authority, I don't think it's likely that any point is going to be taken on that. But it does mean that if the appeal is allowed and the submissions of all the parties and the interveners are accepted that the authorisation was required, this would have the effect that he has been unlawfully deprived of his liberty since the handing down of judgment.
Presumably, the parents who've continued to accept the necessity, they've been consenting.
They have been, yes.
To it, and he's still under 16. So in terms of the legality of it, the bedrock of their consent has been there.
Yeah, they have consented. Yeah. They were consenting at the time, and the Guardian agreed with the position. But of course, that was a part of the process of the court.
Yes, but the Guardian doesn't have any consent to it.
No.
Yes. Good.
So that is where we got to, and then in her judgment on the 24th of June, Mrs Justice Lieven set out her conclusion that the court's authorisation for the deprivation of Jay's liberty was not required. The essence of that judgment is that, in her view, Jay is not deprived of his liberty within the meaning of Article 5 because the effect of the care order, which she had also granted, was that the local authority could give valid consent to the arrangements for his care, such that his situation became entirely outside the scope of Article 5.
Yeah. Yeah.
And it is that decision against which the Guardian appeals, and as Your Lordship indicated, that is supported by all the other parties and by the interveners. So, my Lord, that's the opening, and given where we are, I don't propose to go through anything in our skeleton in greater depth, but I thought it might help. I will deal with the point that Your Lordship raised at the outset.
Yes.
To explain where we are, and then otherwise I thought it might help to very briefly set out what we think the proper approach should have been, in case that
Thank
is.
Thank you. Well, that's acceptable.
The position on paragraph 62 of paragraph 63 of the skeleton, which has certainly become more contentious than I envisaged when we drafted it. That submission was a wider submission than the main thrust of grounds 1 and 2, which is that a local authority, and I'll come back to that, cannot, by virtue of a care order, consent to the give valid consent within the meaning of Stalk, I'll call it Stalk 2, to the very confinement which it has created within the meaning of Stalks 1 and 3. The wider point that was made was that, partly because one way of looking at it is simply within the scope of parental responsibility. The wider point that was raised was that that the Guardian contended that authorising the particular arrangements in this case would not be something within the zone of parental responsibility.
Whether you be parent or
yes,
local
and I'm gratefully going to adopt Ms Clement's definition of natural persons with parental responsibility, which which appears to us the appropriate way of distinguishing them from the corporate body of the local authority. My Lord, that submission is not set out in detail in my skeleton, as you've seen. It's briefly referenced, and there is case law suggesting that this might be the case, but certainly nothing decisive. Probably the strongest hint, and it is only a hint, that I referred to is that of Lady Hale in Re D, when she can take to the point of the paragraph is referenced in the skeleton, which is where she says that logically her conclusions would apply to a child under 16. But both Lady Hale and Lady Black, in that case, specifically went on to say that the point did not arise in the case. They hadn't heard argument on it, and they thought that it was better that it was left for consideration when the point did arise. My Lord, after we filed our submissions, certainly we have considered all those that have come back. It's correct to say, as was argued in the mother's skeleton argument, that the point was not directly before Mrs Justice Lieven, did not feature in her judgment, and does not need to be determined on this appeal. And in addition, my Lord, certainly this is where the Guardian has come to, having reflected on all the submissions that have been put in particular the very detailed ones from the local authority and the Secretary of State on this issue. It is a very complex question. At the one end, simply because of the reality of the situation, at the one end there will be the spectrum of the spectrum will be the type of case which is envisaged by the Secretary of State in her submissions, the benevolent parents whose parenting has never been questioned, caring for a child at home but with local authority support. At the other end, potentially, is the sort of situation envisaged by Mr Justice Kean in WEAB, where he talks about a child who has been removed from their parents because the threshold of significant harm has been met, and potentially in circumstances where the child may already have been caused some significant damage. So there is a range of parenting at issue. There would be a range of age, and there would be a range of restrictions. And the parties who have disputed the point in more detail in written submissions, and they will correct me if I'm wrong, but they don't in their submissions say that there is unrestricted scope for a natural person with parental responsibility to provide valid consent to a confinement, come what may, and in all circumstances.
Cutting to the chase, it's not a live issue.
No, my lord.
Case.
And I'm sorry if I was a bit too wordy. Yes, it's not a live issue in this case. We think it is a complicated issue.
I think we'd be wise not to go there.
In the politest possible way, yeah. Yes, my lord. That is certainly agreed.
Yes.
And that is the position that we have reached.
I'm sure that's our natural inclination.
I'm very
grateful. The
grateful.
approach of the court generally is to decide what it has to decide and do that, but leave to a case which raises the point on for that to be the focus of attention on that occasion.
Yes, my lords, that will undoubtedly happen at some stage in the future, and then it can be addressed squarely on those facts. Thank you. I won't say any more about that, my lord. What we considered might assist the court would be very briefly to, and I won't rehearse the grounds that are in the skeleton unless you wish me to, and I should say the press have also got redacted copies of the skeleton, of all our skeletons. But I thought it might assist to set out what we say is the proper analysis of Article 5, and in particular to identify the components of a deprivation of liberty within the meaning of Article 5, and to set out in particular the distinction between what those components are and the consequences of identifying that all the components are present and that a deprivation of liberty is therefore there. And I raise that because there is some, throughout both judgments and other writings, there's quite often a language that is perhaps apt to confuse. And there's some indication of that even in Mrs Justice Lieven's judgment. If I can just explain what I mean. My Lord, the components of a deprivation of liberty are not contentious. They are identified in Stork and Germany. They are, this is tripe law now, the objective component of confinement in a particular restricted place for a non-negligible length of time, generally called the confinement. The second is the subjective component of the lack of valid consent. And the third is the attribution of responsibility to the state. And those three limbs are conventionally called Stork 1, 2 and 3, and that's how I'll refer to them if I may. And the first limb of Stork is the actual confinement. Again, this is not a matter of any dispute. Whether or not an individual is confined requires consideration of the precise restrictions in place. It is a matter of fact and degree. And the judgment of the Supreme Court in Cheshire West largely addresses that particular issue, and it is in respect of confinement that Lady Hale articulated the acid test of continuous supervision and control and not being free to leave. But the reason I raise it, my Lord, is that factual situation of confinement is sometimes referred to as the deprivation of liberty itself. And while that may appear harmless in our submission, this is incorrect, and it is, and that particular conflation is apt to confuse when one proceeds then to the second limb of Stork. I think I referred in my skeleton to the judgment in Re AF at paragraph 9, where Mr Justice Mumby, as he then was, specifically said he was distinguishing confinement from deprivation of liberty, and the Children's Guardian supports that approach and submits that it would be helpful for that to be clarified. There is no dispute in this case that J is confined within the meaning of the first limb of Stork, and I don't think I need to say any more about that.
Yes.
And the third limb, again, is uncontentious, and that is the imputability to the state. Again, several cases have addressed this in detail, but there's no dispute here that the arrangements for his care are created by the local authority and attributable to the state. But the second limb of Stork, which is the absence of valid consent, we say that properly analysed, it is important to have in mind that what is being consented to is not the deprivation of liberty, but the actual confinement. If there is valid consent to the confinement identified, the second limb of Stork is not met, and in those circumstances there is no deprivation of liberty.
Sorry, can you just, I was just one sentence behind, can you just say that again, if you can?
We say that the valid consent under consideration in Stork limb 2 is consent to the confinement.
Yeah.
It is not consent to the deprivation of liberty. And so if valid consent is present, the second limb of Stork is not met, and there is no deprivation of liberty to consent to.
Yeah.
And in those circumstances, there is nothing that requires the court's authorisation. But in our submission, we say there is an important distinction between valid consent, which removes the situation from Article 5, and the authorisation from the court or from whichever other body is appropriate, which is required once it is identified that all three limbs of Stork are met and that there is a deprivation of liberty. We are supported in that approach by the judgment in Re T, that is, I think, possibly worth taking you to, my lady and my lords. It's in the authorities bundle. I think it's electronic 186.
I'm afraid,
If you're not,
partly because I've forgotten to bring my computer, but none of us are. So what's the...
I think helpfully, electronic is also the same as real. It's also page 186 in the authorities bundle.
Good.
And at paragraph 160, Lady Black endorsed your lordship's judgment in the Court of Appeal, saying that there is an important distinction between, on the one hand, determining whether in any given set of circumstances someone is deprived of their liberty for Article 5 purposes, and on the other, making an order, whether under sections 25, 119 or the inherent jurisdiction, authorising a local authority to restrict a child's liberty. The former is a factual question involving categorisation of a specific past or present set of circumstances. The latter is a prospective author authorising but not requiring a local authority to take steps in response to events which it is anticipated are likely to occur.
Yeah.
So we say essentially there are two questions. Firstly, is there a deprivation of liberty, which involves, as set out in Re T, a factual assessment of limbs 1 to 3.
Yeah.
And secondly, if the answer is yes, should that deprivation of liberty be authorised? And we say at that point that the court considers whether the requirements of Article 5 are met, in particular whether the appropriate safeguards are in place, whether the arrangements which the court is being asked to authorise are necessary and proportionate to the risks that are present.
Can I just ask you about that? That language of necessity and proportionality is very often used in the context of the qualified rights in Articles 8 to 11. Article 5 is structured differently. There isn't an open-ended possibility of authorising things, for example, to protect the rights of others if it's necessary and proportionate. So can I just ask which of the subparagraphs of Article 5.1 is relied upon in cases like this?
My lord, it's often not specifically addressed, but we agree with the submission made in the skeleton argument submitted by Article 39 and Mind, that the two possible limbs of Article 5.1 would be Article 5.1d and 5.1e.
Yes.
So going to that in the authority manual.
Yeah, that's at page 10.
It's at page 10. I'm grateful.
So paragraph D applies to a minor.
Yes, my lord, I'm just trying to find the bit in my note where I've made some notes about it. Paragraph D applies to the detention of a minor by lawful order for the purposes of educational supervision of his lawful detention. The second half of that is not material.
No,
it's conventionally the purpose of educational supervision. And then E is the lawful detention of persons of unsound mind.
Yes, yes, and that could apply to someone who is no longer a minor.
Yes, Typically, when in the Court of Protection, or certainly the jurisdiction relating to vulnerable adults, that is the article. That's the limit of the article to which one looks.
And although Article 5 doesn't, in terms, refer to necessary in a democratic society, which Articles 8 to 11 do, I think it's now well established in the jurisprudence that the word lawful embraces that by implication.
Yes, I think my submission would be that what the case law endorses is that the deprivation in question, so the restrictions in question, have to be necessary and proportionate to the risks posed to or by the person who is being detained. Often both. So it's a different. It's not so much a qualification as a requirement, and what the court will do is will scrutinise whether those restrictions are unduly onerous. In which case authorisation should not be given, or whether they are in fact entirely proportionate to the harm that they are trying to prevent.
Yes, thank you.
Just for completeness, my lord, the two cases that have addressed this at all are Re T in the Supreme Court, and where Lady Black says, I can take you to it, but you may just be happy to have the reference. It's page 169.
Which paragraph? What paragraph?
It's paragraph 87 to 88 of Re T, endorsing the earlier judgment in the Court of Appeal in Re K. In Re K is also in the authorities bundle at 229, where the matter was considered. So in Re K, considered the situation of a minor because it was argued that what was being provided by way of arrangements for care did not constitute educational supervision. In Re K concluded that there is a broad interpretation of that, and at paragraph, it's page 241 of the authorities bundle. Make sure I can give you the right paragraph. It is only at paragraph 64, only where there is no present or reasonably imminent educational provision does the Article 5.1d defence fail. In Re T, the court, Lady Black, endorsed that and said it had not been argued at first instance whether the case fell within little d or little e of Article 5.1. So she said it would take matters no further to go into it, but she agreed that that educational supervision has a broad interpretation. Conventionally, I think it tends not to be addressed in any detail in these applications, but I think if one thought about it, one would say that that's where one was.
I mean, coming to this from a bit of a distance, but it seems to me that Article 5 is not written directly with the sorts of cases that we're dealing with in mind. So the phrase education has had to be the entry through which we've passed in order to come within Article 5. And so it's been stretched
Yes.
to do that rightly. But that's what's happening.
I fully understand that, but speaking for myself, it is important, I think, that no area of our social life or legal system should become a silo. And the light of Article 5 needs to be shone on this, and just because nobody in practice any longer raises the issue, nevertheless, I think it is important for us always to keep in mind that Article 5 says what it says.
Yes.
And it's our duty as courts to apply the law. Whatever might be thought by people to be a good idea, and that people should be confined for all sorts of reasons, for example, in their own interests, unless it can be brought within the terms of Article 5,
Yes.
there is no open-ended let-out.
Yes, my lord, we would entirely agree with that, and we would say that it is not a qualified right, in the same way that Article 8 is qualified as to what is necessary in a democratic society. The broad construction of educational supervision is perhaps a natural extension when one looks at the typical arrangements, even where they are highly restrictive for somebody in Jay's condition. It may include some form of education or support in its broadest sense.
Yes, exactly.
Even if it is simply supporting him to manage his own behaviour.
Yeah, I have no reason to think that anyone is acting contrary to law.
No.
All I'm urging upon everyone is that we, from time to time, remind ourselves of what the lawful basis of all of this is.
Yes, my lord.
Yeah.
We would entirely agree with that.
You were led into that by saying there were two cases that refer to this issue, and Re-T was one. Was there a second case?
The second case is in Re-K, which is the one in the authorities bundle.
I see.
They're both.
You told us that
yes.
the Lady Black relied on.
Yes, it's in the authorities bundle
at 229.
At 219, and the relevant page was 229.
Yeah.
Where the case was specifically argued in the Court of Appeal.
Yeah.
And then Lady Black agreed that there was a broad interpretation, but said she would not consider it further because it hadn't been argued at first instance. So, my lady and my lords, where I was saying that there are two distinct questions about whether, firstly, is there a deprivation of liberty, and secondly, should that be authorised? And for completeness, if the local authority in its skeleton suggests that both acknowledges the distinction between valid consent and authorisation, but says that both can fulfil the second limb of stalk. And for the avoidance of doubt, our analysis would be that the proper interpretation is that authorisation is not something that falls within the second limb. It's, yes, entirely my lady. It is sequential. It's what you do once you've identified. The judgment under consideration of Mrs Justice Lieven, which you have in the main bundle at the monitor has now you have it at D1. And the language in the judgment does periodically refer to the local authority consenting to the deprivation of liberty. It is perhaps most clear in paragraphs 23 through to 26. Where she considers whether the local authority can consent to a deprivation, goes on to say if there is valid consent, there is no deprivation, and then says the key question is the scope of the power the local authority's power to consent to a child's deprivation of liberty at paragraph 26. It is
You're
clear.
saying consent to the confinement, which would would result in there having been a deprivation of liberty.
We would say that the correct analysis would be that, and the correct language to use would have been to use the word confinement instead of the words deprivation of liberty. But we say, looking beyond simply the language, it is very clear from the judgment that her approach was to ask whether the local authority could give valid consent to the arrangements it had created for Jay's care. And her conclusion, which is equally clear, is that if it could, there is no deprivation of liberty requiring the court's authorisation. So we say her analysis of the questions was correct, if her language was not as precise as might always be helpful, but we do say she reached the wrong answer. My lady and my lords, the reason we say this matters is because it is the authorisation process that that then considers whether the requirements of Article 5 are met. Having recognised that Article 5 is engaged, the court will then consider whether the necessary safeguards and protections are in place. And again, the judgment of Re T at paragraphs 153, 155, that's in the authorities bundle at 184.
Just while we're doing this, for my part, I don't think I've had the electronic copy of the authorities
Oh, I did.
bundle. It may have come to me when the case was listed for December, but it hasn't got as far as where it's. So could it be sent again?
Yes, of course.
It's not a problem because we've got this breeze block of a thing in front of us. Yeah.
Can I?
I wish I had a breeze block because I've got a thing that falls over. But yes, of course, my lord. I'm very sorry.
Make it clear, and I think it must be something that happens as a result of the electronic bundles being that when it's double printed, which of course is done for cost and convenience, or contrary to the practice direction. If a new case could start on a new page, because you can't put tabs.
You can't put tabs. I completely
with
understand, my lady.
Substantial bundle of authorities, it just makes it quite tricky.
I'm very sorry, my lady.
Sorry about that, please. No, it's the third case in a row. Well, I've had this.
and I know if I have to use paper bundles, that I'm always in exact. Then I end up photocopying one page to put it on, to have it separate.
Well, I didn't have the nerve to ask my clerk to do that, so I.
But Ms. Rook, we've done jolly well. We've done 48 minutes before there's been the bundle. then there's been 2, but hopefully we can move on. So Re T starts at page 344.
Yes.
And you wanted paragraph 153, I think.
Paragraph 153 and 155 we say are helpful on this point.
No, I've got the wrong Re T. Court of Appeal.
It's at 184 of the. I'm hoping it is anyway. 184 of the authorities bundle.
Yeah, thank you. Yeah.
And so, while this was considering applications to authorise accommodation which was akin to a secure accommodation order within the meaning of Section 25 of the Children Act, the process for considering whether a specific situation meets the requirements of Article 5 is, we would say, the same. So at 153, Lady Black says there are appropriate procedural safeguards built into the application process, and the reason for that is the need to comply with Article 5. And at 155, she went on to say that the court would not give the local authority the authorisation that it seeks without considerable exploration of the circumstances to ensure that the proposal is appropriate. And then she picks out a number of particular safeguards. And my lady and my lords, I don't propose, because it's not an issue in this appeal, to go through precisely what the requirements of Article 5 are and the procedural safeguards and protections. It is widely agreed that they are quite detailed, and they are set out certainly as regards the requirements of the statutory scheme for both Section 25 of the Children Act and the Scheme for Detention under the Mental Health Act, they are set out in detail in the helpful witness evidence that's been filed in support of the first intervener, Article 39 and 9. In particular, those safeguards include a defined set of criteria to be satisfied before authorisation is given. Critically, some form of representation to ensure that the voice of the child or the vulnerable person or whoever is detained is heard in the process and that their wishes are made known to the court. Thirdly, there is a requirement of a defined time limit, which is usually relatively short. So, for instance, under Section 25 of the Children Act, the initial time limit beyond an emergency is 3 months. And then there has to be a further authorisation every 6 months. Under the Mental Health Act, there is never more than 1 year permitted from consideration of whether the detention is appropriate. And there are shorter time limits currently under proposal in the Mental Health Bill. Another further point of comparison is the statutory scheme under the Mental Capacity Act, which permits a maximum authorisation of 1 year and which is echoed in the re-ex process when vulnerable adults are deprived of their liberty within the community, so require the authorisation of the court for that process. So my point is that it needs to be a defined time limit and it needs to be relatively short, and then there has to be a system of regular reviews. And again, it's not contentious. Article 5.4 requires the specific safeguard of the availability of speedy review by the court. It's page 10 of the authorities bundle. Actually, I'm sorry, it's page 11. I hope it's page 11. Yes. So, and that is, again, has been discussed in the case law, and if it was contentious, I would certainly be able to take you to it. You have the authorities in the bundle, but again, it's not contentious. In particular, where it's probably addressed in most detail is the Re-J, sometimes called Re-AJ case of Mr Justice Baker, as he then was in 2015, which you have in the authorities bundle at 435. And a speedy review means that by a court means that proceedings have to have a judicial character. They must be accessible to the person detained. They must not be dependent on the exercise of discretion by a third party who may simply agree that confinement is in somebody's interests. What Mr Justice Baker says is a guarantee of a fair procedure for reviewing the lawfulness of detention. So that's a very brief nutshell of some of the safeguards.
Very helpful.
But we say it's important to consider that process because the effect of Mrs Justice Lieven's decision was to short-circuit that entire authorisation process and so deprive Jay of all the safeguards and protections to which he was properly entitled under Article 5.
Yes.
And my lady, my lords, there is agreement that the local authority was not itself able to give valid consent to the confinement. I am very happy to take you through the relevant case law. It is set out in the skeletons. I'm very much in your hands as to whether or not it would assist.
For my part, I don't think we need to. No. It is very well set out, and we're very grateful for that.
I'm very grateful. Essentially, our case is that the reasons that Mr Justice Kean gave in Re-AB in 2015 are essentially correct. That is why the local authority, as an organ of the state, cannot properly give valid consent to the very confinement which it is creating.
It can't mark its own homework.
Indeed, my lord. And he specifically considered the one area of review that might be advanced. It's not advanced by this local authority, which is that there's the child care, the looked after child review, and he Mr Justice Kean said, that would not, in my judgment, afford the required safeguards and checks sufficiently independent of the state. That was endorsed by Mr Justice Mumby in the Re-F case. I won't again say it's set out in the skeleton. The two other cases which have addressed the point in relation to natural persons with parental responsibility, Re-D and the TGA case of Mrs Justice Lieven, don't, in my submission, take the matter further when we are simply focusing on the ability of the local authority to give valid consent. We do agree that the Re-T case in the Supreme Court, although it is focused on Section 25 and comparable secure accommodation within the meaning of the statute, did proceed on the assumption, which was endorsed by the court, that the local authority could not have given consent to that confinement itself, and that was also, I think, in the Court of Appeal before your lordship,
yes.
the position. It wasn't, of course, argued on any part by anyone that that shouldn't be the case. So we say that the short point is that is simply not possible. There is nothing in the statute suggesting this was the intention of Parliament. It would be entirely contrary to the requirements of Article 5 because it deprives the child of any of the proper safeguards. The child ends up entirely unrepresented. There is no defined time limit. Potentially, the arrangements for the child could be changed or intensified on an arbitrary basis. They could be changed in a way that was not commensurate with the child's best interests, simply for convenience, for the sake of economy, for the sake of making it easier to accommodate multiple children in the same environment. There are many practical reasons why the absence of scrutiny has a material effect. Certainly, I think Mr Broach intends to address you on some of the practical consequences of court scrutiny. There are some vivid examples in his submissions, and that certainly reflects the experience of, I think, most of us who do these cases on any sort of regular basis, either in the family court or the Court of Protection, that the court's oversight has a genuine material benefit to the person who is being deprived of their liberty. It's a point made in the skeleton filed on behalf of the father, which we agree with, that if Mrs Justice Lieven was right, it would enable a local authority who had a care order which granted on the basis of a care plan which did not suggest that the child would be deprived of their liberty, to impose arrangements which did have that effect without any court scrutiny or oversight, because there would be no requirement to identify that at the outset.
Looking at the judgment in paragraph 16 in the opening section, the judge, this is the second sentence, she says, in practice, the real purpose of a dole's order is to provide a defence against any future claim for unlawful detention or breach of Article 5 by making a declaration that any deprivation would be lawful. Then she goes on to say that's pretty fanciful in this case because of the sad circumstances that Jay is in. But presumably you would dispute that description of
yes.
the reason why we have doles. You say absolutely not. It's because of Article 5.
Yes, yes, my lord. We would say that the reason for having a court appellation is to make sure that Article 5 is complied with and to ensure that the vulnerable people and the people in this cohort are some of the most vulnerable in our whole society. have the rights and protections, the checks and balances on the arbitrary exercise of state power to which the Convention entitles them.
And the fact that the Article 5 process triggers the sort of hearing that had been set up before Mrs Justice Lieven, where everybody's in agreement as to the circumstances, doesn't obviate the need for that to happen. And it's circular, isn't
Yes.
it? The judge only knows that everybody agrees because there's been a table, as it were, that they've all come round, including the independent representative of the young person, who only exists because of
Yes.
the court process, namely the guardian. And it's only at that stage that the court knows, in this case, that everybody accepts that this is what is required.
Yes, yes, well, that is entirely what we say. And it's part of our third ground that Mrs Justice Lieven took into account the fact that both the parents and the child's independent guardian supported the placement in reaching her conclusion. And we say that was a circular argument because she only even knew that. On her analysis, no one would have had to consult the child's parents, or that there would have been no court-appointed guardian to represent the voice of the child, to consider independently whether that placement was appropriate for him. And you'll have seen in the local authority submissions, they also dispute that as being the purpose of their own application. It may be a motivating factor, but that is, in our submission, very different from the purpose of the process itself.
Yeah.
Does the judge mention Article 5, paragraph 4?
I don't think she did.
Does she give weight to the fact that that is another freestanding right? So it's not just paragraph 1 has to be complied with, but paragraph 4 has to be complied with. She doesn't mention it in paragraph 16. That's why I asked the question.
My Lord, my understanding of the judgment is that because she considered that the local authority could consent to the confinement, Jay's situation falls entirely outside.
No, I
Article
appreciate
5.
that. But
Yes.
it's just that in identifying the purpose of Article 5, does she mention that one of the purposes of Article 5 is set out in paragraph 4?
No.
No.
I'm sorry, my Lord, I didn't answer the question.
No,
Yes.
that's what I.
No, she does not.
That's what I'd understood.
Yes. I
And,
will.
and I think you would say that even if everyone is agreed, that one of the reasons why Article 5.4 is there is to make sure that the court doesn't have a rubber stamp, but
Yes.
does what it's supposed to do as a court.
Yes, my Lord, and Article 5.4 has it's certainly been considered in some detail by Mr Justice Baker, as he then was, and one of the authorities which you do have in the bundle, it's which is RD. I won't take you to it in detail, but it's the duties, and it's at 588 of the authorities bundle.
So page
588 of the authorities bundle. My Lord, it's a decision it's not a decision about children, but it is a decision about the purpose of Article 5.4 and what is required to satisfy them. And in particular, it's a decision about who should be appointed as the representative of a vulnerable adult who is deprived of their liberty under the Mental Capacity Act, authorised called the administrative process, which is Schedule A1. And the essence of the judgment is that the representative has to be sufficiently independent and also has to bring proceedings, even if the representative thinks that the deprivation of liberty in question is appropriate and in P's, it's usually called P's best interests, if P themselves are objecting. Because the point and purpose of Article 5, Mr Keane is going to correct me if I get this wrong, is to ensure that that objection is before the court and that the court can properly consider it. For very similar reasons as to those set out by the Children's Commissioner in respect of children, one never knows until the situation comes under the court's scrutiny often whether actually matters could be improved. So this is why it's not just a matter of principle, it is a matter of real benefit to the vulnerable children and vulnerable adults who are entitled to the protections of Article 5. It is important that they have that right to recourse to the court.
So what the judge did at paragraph 25 of her judgment is simply circumnavigate Article 5.4.
Entirely, my lord. I've slightly laboriously gone through the analysis of Article 5 because I thought it might assist the court. Our two grounds, our ground 3 which is that Mrs Justice Lieven wrongly took into account and relied on various factors. I think that's probably adequately covered in the skeleton. It's also, and I'm also conscious that the Children's Commissioner's submissions are directed to this ground. I don't want to take up all everyone else's time as well. And again, ground 4, we say that Mrs Justice Lieven failed to have regard to the outcome of her decision, which was quite, the potential is stark that the restrictions could be placed, could be increased on Jay, whether or not that is in his best interest. He could be moved to an alternative provision without any consultation with anyone, certainly on his behalf. And ground 5, we say that Mrs Justice Lieven did not have regard to the paradoxical outcome of her decision that following Re D in the Supreme Court, when Jay is 16, his parents will categorically not be able to consent to any deprivation of his liberty. That is decided once and for all by the judgment of the Supreme Court. But if Mrs Justice Lieven is right, the local authority will be able to carry on authorising its own homework, to use the Lordship's phrase, marking its own homework until the expiry of the care order when Jay is 18. And we say that has to be simply contrary to the logic and the requirements of Article 5.
Yes.
But then, when Jay becomes 18, the aftercare provisions obviously bite, because he's been in care of the local authority for 13 weeks and all that. So at that stage, they then would have to get a DOLS because the care order would have expired.
The care order will then expire and then
come under the Court of Protection.
they will be making
demonstrations.
Yeah.
And
the time will presumably come fairly soon after his 16th birthday, when the local authority will dovetail the case into the Court of Protection.
Yes. My lords and my lady, that's all I had to say on the discrete points that we're making about why we submit the appeal should be allowed. Yeah. If there's anything else on that I can assist you with.
I think not. No, it's been very helpful.
I'm very grateful, my lord. The only other point that I would wish to raise at this stage, and I think it may not, I've had some discussion with Ms Kavanagh, I think it may not be contentious. We would say that if the appeal is allowed, that the deprivation of Jay's liberty should be authorised for the period that Mrs Justice Lieven clearly would have authorised it had she applied the proper process, which is until the 1st of March 2025.
Right.
So we know that the local authority would be...
So the purpose of that is that the outcome would be as if the judge in June had authorised the deprivation of liberty. It would have run for 9 months.
Well, it would have been from the 1st of March because that's when the hearing took place.
I'm with you, of course. Yeah.
So what our submission would be that there would be no objection to the local authority asking for authorisation for that period, but we would say that to comply with Article 5, and for all the reasons we have just gone through, at that point, before that point, it needs to be reconsidered properly by a court, there needs to be the proper process whereby the local authority...
Because of the course that Mrs Justice Lieven took, I'm presuming at the March hearing, de bene esse, but of course not using that in any Latin sense, she looked at the details of the dolls then. Otherwise, there's been, because of the course she took in her judgment, there hasn't been a judicial determination of the content of the dolls.
No, my lord, there hasn't, and it's also fair to say that that she didn't approach it from the question of whether the Article 5 safeguards were being met,
But it does
because
occur to
she
me
short-circuited.
that it is plainly appeals going to be allowed. So it does occur to me that there may not have been an ordinary dolls hearing. We're all engaged in this because of the importance Article 5 has in triggering this process. So if that took place in March, then
I think looking at the order, I think the hearing was only about 2 hours.
am I making him out of the law? Yeah. Yes, whether she
Yes, I've just confirmed with my very helpful junior that the hearing was, she says certainly 2 hours at the most. But the position of everybody at that hearing, including the children's guardian, was that the Jay was deprived of his liberty and that should be authorised for a period of a year.
Right.
That, I appreciate, is not quite the same as the court providing its own scrutiny, and it's partly for that reason that we say the matter should be remitted back to a judge of the division to consider it properly.
In
March. So that's in reality.
And in the meantime, we've got the supplementary bundle of the fresh evidence, which gives us the current care plan.
Yes.
And I haven't compared that. I've read through that with the original evidence, but am I right? There's been no substantial change in his needs. And his
We don't think there's been a substantial change, but my lord, the children's guardian has not had an opportunity to consider that in detail, and he has not, in particular, had an opportunity to carry out the inquiries he usually would, which would start with making contact with the placement and having a
that's
discussion.
something that might happen between now and March.
Yes, and he may wish to go and visit Jay. The whole process of what...
If the appeal's allowed, then we would have to make a fresh dolls authorisation. Or we'd simply continue continue the order that the judge made that ran until June, but might have run until this month.
I think for the avoidance of doubt, it would probably be helpful to have a fresh a fresh authorisation.
Yeah.
And we would say that because the local authority has now filed its updated evidence, what there needs to be a short time for is a response from both mother, father, and then the children's guardian, and then a further hearing before the judge of the division.
And this is something for you all to consider, obviously, my lady and my lord. Normally, these are longer running dolls authorisations go back to the local court so that there's some continuity of judge. And Judge Barlow, who was then presumably sitting in the Bristol area,
yes,
had the case, but it may well be that we should send it to the Judge Barlow's now moved. We should send it to the Bristol, because there's no reason why it should stay with either Mrs Justice Lieven or any other High Court judge.
I don't think so, unless I'm corrected by those who are slightly more familiar with it than me. My understanding is that
that's what would normally happen in the dolls list, as we call it.
It's normally dealt with by a Section 9 judge sitting in the regional court, which is what Judge Barlow was at the time.
Certainly what I've got in mind, and so if anyone wants to put forward a different outcome, then please do. I gather that we're not going to try and divert your lordship from that path. No. Good. Well, Mr. Ripper, that's been really helpful.
I'm very grateful.
Is there anything else? Nothing else from you?
Thank you.
No.
Thank you very much.
Now, looking along the line, and hearing from Ms Roper that she was trespassing on the time that had been allocated to everyone else, my heart didn't sink, because it's always good to hear from all of you. But it does occur to me that the ground's been traversed very effectively on paper by each of you. So I'm keen to hear any points you want very shortly to put before us, but I don't think we need to have the full works, as it were. And this is not meant personally, Ms Cameron.
I can't take it as such, my lord,
Yeah.
nor do I intend to traverse the entire ground, nor will I take up the 45 minutes that was notionally allocated to me. I say those things boldly and hope that I can fulfil all of them. I have only 4 points, and they're short, and then I'll deal briefly with that point, because I agree with my learned friend in relation to the order to be made. Before I do, my lords, my lady, just dealing with the factual point about the positions on the ground in front of
Yes.
the learned judge. Local authority made their application for the Deprivation of Liberty Authorisation on the 23rd of January 2024, which you have at B1 of the core bundle, which is electronic pagination 67.
Yeah.
You're aware the care order was made on the 1st of March. That's at B27, page 87 to 88 of the core bundle. And the order, of course, was changed from the interim order on the 25th of June 2024 at B29, electronic page 95. Therefore, the reason that, of course, the learned judge effectively made no order on the authorisation, it was because she had concluded that the local authority's consent was valid, and it's on that basis that we have therefore proceeded, because we have parental responsibility in relation to this young man, and it was right to say that the reason for taking the application for the care order in the first place was because there needed, as my lord foreshadowed, to be very active or proactive parental responsibility used on the ground. So for those reasons, we have proceeded since the order was made discharging essentially the authorisation that our consent is valid and lawful, because that's what was found as a fact by the learned judge in the court below. Having gone to the court to say we had concerns about utilising the parents' consent, the very reasons for the application, quite wrong for us to now try and hide behind that and say that's what we were doing. But it is right to say that they work very cooperatively with the local authorities, so it's almost on a practical level a distinction without a difference. You will note in our skeleton argument at paragraph 13, and I am instructed, but the local authority were very uncomfortable with the idea that they should be authorising the very detention that they created. And my junior at the first instance, despite this being essentially something put to them, offered to the local authority, was continued to be instructed and did oppose that and argued fully in the way that the learned friend has set out, that we ought to have an authorisation. So turning then, if I may, to the 4 points briefly. The first I wish to deal with is how the type of placement, the type of placement affects the procedure to be adopted, and the relevance of consent. But just to foreshadow that, that's of course the difference between those secure accommodation which are regulated and the like secure accommodation, and the sort of placement we have here, which is where the primary purpose is for care and support, but the arrangements for the child would amount to essentially a detention, the concrete situation would. The second point then is the Article 5.1 procedural imperatives to avoid arbitrariness, and whether our consent could provide that's very much touching very briefly on that in the light of what you've heard. I do wish to go to the HL judgment briefly, if I may. And then the second point, my Lord Justice Singh has of course raised, is to deal separately with Article... I should say the third point is to deal with under Article 5.1. There are care orders in which we are not the detaining authority. Perhaps a child's admitted into hospital, and we nevertheless have arrangements, and we have parental responsibility, and of course consent to PR using your parental responsibility if you're not the detaining authority that's another facet that I wish to touch upon briefly, if I may, because of course, it's not just a narrow point that we're the detaining authority, we still have positive obligations under Article 5, which would mean we would say that nevertheless we shouldn't be consenting. And then Article 5.4, my Lord, Lord Justice Singh's point, the procedural distinctions, the procedures are distinct once somebody is deprived of their liberty. You've heard, and I won't touch upon it again, that the child looked after review is not sufficient. That's Mr Justice Keane. But there are, of course, other routes, writ of habeas corpus, JR, and there's some European court dicta that's very clear that those are not sufficient either. And so I just wish to just touch briefly on that so that you have the complete picture, and you have the point on the order for the appeal to be allowed. No doubt that's a few seconds in light of the very detailed way my learned friends dealt with it. So if I may. So the type of placement concerned here is one where the primary purpose of the provision is for care. The care package and the placement itself, therefore, has had to have restrictions on the liberty of J, which, absent authorisation, would mean his situation amounted to a deprivation of liberty. Lady Black in the court of, in the Supreme Court in Re T, and that's paragraphs 138 to 139, which you have in Authorities Bundle 180 to 181, goes through the different types of placement, but they essentially come to three. The first is a purpose-built placement, using the language of Lady Black, which is approved by the Secretary of State, i.e. a secure children's home to which Section 25 directly applies. The Children Act, of course, Section 25 of the Children Act directly applies. So designed for the purpose of restricting liberty of a child. The second category is accommodation which, although not designed for, has its primary purpose as the restriction of a child's liberty, which could be termed like secure accommodation. And the third category are those placements where the primary purpose is the provision of care and treatment, rather than preventing the child from absconding or causing themselves harm. But those placements, though not equivalent to secure accommodation, have a range of and level of restrictions imposed on a child, which all in all likelihood would meet the concrete situation required under Limb 1 of Stork.
Right.
To be clear, we say this case falls into the third category. My Lord, the President in the Court of Appeal in Re T, which you have in Authorities Bundle, and in particular I seek to take 79 to 82, paragraph 79 to 82, you have it 366 to 7. My Lord's analysis comes to the point that, of course, the first two categories are essentially secure accommodation. Parliament enacted a statutory scheme which required a court order and a court process for that level of restriction for any child. And my Lord, Lord Justice, the President stated that any restrictions that are essentially secure accommodation, even if they are not in an approved placement, i.e. category 2, cannot avoid the sort of procedural imperatives of that scheme, and therefore approved only the route of the inherent jurisdiction. However, my Lord, in paragraph 84, and that's at the Authorities Bundle 367, perhaps it might be helpful just to go to that. Okay.
Yep.
my Lord, in conclusion, said that should make it clear that this does not concern the placement of children in other than equivalent of secure accommodation. Different considerations will apply when an application is directed towards and only directed towards deprivation of liberty. I pause to note that that appears to encompass the third category of placements with which J is in. In that situation, subject to De Wilde's case, the question of whether or not the subject of the application to the authorisation of a young person under the inherent jurisdiction is in agreement with the proposed regime may form part of the evaluation of whether such authorisation is necessary. Of course, T was saying, I can consent, I'm Gillick competent, and therefore you don't need an authorisation. And my Lord Justice the President drew the point, the distinction that secure accommodation requires your consent.
Just wondering why this matters for this case.
Forgive me.
Why this matters for this case, because we're not dealing with secure accommodation. What's the distinction you're seeking to flag up?
Point forgive me, I have not been clear. The point I seek to make is that when one gets to the third category, consent, whether that's parental consent by a natural person, and we are here dealing with consent by a local authority, it has a relevant factor in the question of whether an authorisation should take place. I'm seeking to be clear to draw a distinction, because there's a great deal of dicta cited in a number of the skeleton arguments which relate to the first two categories. Yeah. And it's right to say that my Lord has been clear, and the Supreme Court supported the conclusions of my Lord, that those cases, consent is not permissible in any event. One needs a court order, a structure similar to Section 25. So it's this other category, which not all the cases relate to, that consent can be a factor as to whether you make the authorisation. Forgive me, it's a long way of making the point, but I felt that I just need to be clear about it.
But if you've got a young person under 16, this age, and the parents are consenting, there's no court process at all. There's no need for Section 25 if there doesn't otherwise a need for it. No need for adults.
Save in circumstances where it's almost akin to secure accommodation, where there's arguably a need for, if it's in the category described by my Lord.
So the purpose of the accommodation, you say this is predominantly care and treatment, doesn't trigger of itself a need for adults. It's the lack of valid consent. It's Article 5. It's number 2 limb of Stork.
Yes, but the slight distinction is that for cases where it's akin to secure accommodation or secure accommodation, on the basis of the analysis of the Supreme Court and Reety and my Lord, that the procedures required require inherent jurisdiction authorisation, consent of a parent would not be sufficient, or anybody would not be sufficient because of the reasons set out. So consent really only applies to cases where the purpose of the accommodation is for care and treatment of an individual, but that child is deprived of their liberty.
Right. Well, I'm struggling with this. Yeah.
Was suggested that it's your analysis, which I've obviously
not
done a very good way.
Yes, that assumes that I recall my analysis of 7 years ago, with the clarity that I had at that time.
I just move then, if I may, to Article 5.1 and Article 5. Sorry, I've cut out a point. Just to deal with my Lord Justice Singh's point about the gateway under 5.1d. The case of Bree K in this court sought to deal with the question of whether or not these cases do fall under Section 5.1d. That was an approved secure accommodation case. You'll find it in the authorities bundle at 234, paragraph 38, where this court relied upon an authority which was then quite new from the European Court of Konisaka, forgive me, against the UK, which is now reported, which wasn't then reported, at 2030 EHRR CD 139, and of course there sets out the quote, the full quote, about how education is to be widely interpreted for the purposes of Article 5.1, and the quote from the case is set out. I just wish to complete my learned friend to dealt with the points, and I agree with the points made by my learned friend, but that's a helpful summary as to the broad interpretation of education for these purposes from the European Court. That might apply to a young man, of course, who is in education like Jay, but I take the point, it's very difficult in other cases where, for example, a young person isn't in education at all. But that's not this case, so I'll move on. So the essential...
But I've never seen a care plan, even if they've not been in school for years, been refusing to go to school, where there isn't some education plan or scheme to try and put in place some form of education, no matter how limited.
And moreover, the psychoeducational work that's very often in these care plans to support the young person to regulate their behaviours, to move towards some independent tasks within the household, all of which would fall under the broad interpretation in our respectful submission of the European Court in that case, and also as approved by this court in the UK. Forgive me, the essential purposes of Article 5.1 is to strictly regulate the circumstances in which a person's liberty can be taken away. And 5.4 is a requirement for a review of the legality of the detention thereafter. I take that, of course, from paragraph 123 of HL in the United Kingdom, which is in the authorities bundle at 171. The key purpose being to prevent arbitrary and unjustified detention, whether a detention is arbitrary. When a detention is arbitrary, it's unlawful. To be lawful, it must comply with the procedural and substantive aspects of domestic law, and then observe the procedure prescribed by law as a general requirement under Article 5.1. Even if it can be said that the procedure meets the national law, it must also meet the standards of lawfulness set under the Convention, and under HL in the UK, that's set out in paragraphs 114 to 115, Authorities Bundle 781. And we note in paragraph 115 it must conform to the essential objective of Article 5, to prevent a dole in an arbitrary fashion, and that objective and broader condition that detention in accordance with the procedure prescribed by law requires existence in the domestic law of adequate legal protections and fair and proper procedures, and they drew that, of course, from the Winterberg Netherlands case and the Amour in France case, and that's in paragraph 115. So if the detaining authority can consent to the detention be removed from the scope to be removing a child from the scope of Article 5, there are no fixed procedural rules by which that detention is conducted, and borrowing there, of course, the phrase used by the European Court at paragraph 120 of HL and the UK, and you'll find that at Authorities Bundle 782. The overall result of the process identified by the Honourable Mrs Justice Lieven is a lack of procedural regulation, limits, and a lack of limits on detention. In truth, there was no term to this detention. There was no requirement for review. And such were in the same territory in our respectful submission as set out in HL and the United Kingdom at paragraph 121. And that's the Authorities Bundle 783. Maybe I'll just... Yes. And that effectively is that as a result of those procedural regulation and limits, control has been left in effective and unqualified control in the hands of the local authority. And the very purpose of procedural safeguards is to protect individuals against any misjudgments and professional lapses. I'm suggesting there are, but the fact is there could be.
Yes, the background was that the House of Lords held that what happened in HL was lawful.
Yes.
Under the common law doctrine of necessity.
Despite those procedural...
But the point the European Court of Human Rights is making is that even where something is in somebody's best interests and those detaining act in good faith and all the rest of it, which has echoes of the present context,
Yes.
that nevertheless it's important that there should be an independent judicial review or authorisation of confinement.
My lord, yes, and the proper procedural approach is essentially that's set out in HL in the United Kingdom. That regardless of whether it's in somebody's best interest, regardless of whether it can be said to be covered by the doctrine of necessity as the House of Lords thought it may be, that's not sufficient to meet the requirements of Article 5.1, and a separate part of the judgment I'll come on to in a moment deals with 5.4.
Yeah.
And so, in our respectful submission, HL in the UK has considerable resonance to the situation we're dealing with here.
My understanding is that it was the judgment in HL which then led the United Kingdom to enact the Mental Capacity Act 2005.
And then my lord says that, having been one of the counsel for the government in HL. Is that right?
Yes. We won throughout the domestic courts. It's perhaps another vivid illustration of where the different perspective that Strasbourg offers. So the domestic courts thought what happened was lawful.
Yes.
Yeah, so that consequence in terms of the leading to the introduction of the Mental Capacity Act and the Dole's schedule is really of direct resonance with this case, which deals with the child, who's outside the Mental Capacity Act. But the principles must surely be the same. The approach to be taken must surely be the same.
My lord, yes. If I may deal briefly with the point about that it's not always the local authority who is the detaining authority. So a number of children perhaps who have perhaps taken an attempt at their life or have caused some self-harm or whatever reason have gone into a hospital may be admitted sometimes to just a paediatric ward and held there essentially until safe accommodation can be found until discharge. Sometimes to a mental health ward, but not necessarily detained under the Mental Health Act. They're sometimes also until suitable and safe discharge arrangements can be made. Arguably in those scenarios, a hospital or the trust is the detaining authority. In our respectful submission, that does not it change the imperatives of Article 5 and as set out and the procedural imperatives that are required, which would allow, for example, the local authority with a care order for that child to consent to the trust detaining the child, which on an extension of the reasoning of the Honourable Mrs Justice Lieven, that would be the position. So you might widen the circle of professionals to social workers and treating clinicians, but what you don't do is provide into that system the relevant procedural protections. I've set out, because it's fairly trite law and it's not in the authorities bundle, but of course Mr Justice Mumby, as he then was, in Re A and C Equality and Human Rights Commission intervening, and that was a first instance case 2010 2FLR 1363, set out at paragraph 95 the positive obligations on a local authority when they become aware of a child in their area who is deprived of their liberty. And in particular, of residents here, we respectfully submit, is that so even if we're not detaining, if we become aware of a detention of a child or a young person, indeed an adult in their area, there's a duty to investigate and to determine whether that is in fact a deprivation of liberty. Well, under the facts I've just set out, we would know, so I don't need to trouble you with that. But number two, if having carried out the investigation, we're under a positive obligation, if we find that situation exists, to continue to monitor the situation, and under three, to bring it to an end. And in the event that we can't bring it to an end because it's necessary for the protection of the individual, it is the obligation of the local authority as an organ of the state, if we can't find any reasonable measures to bring it to an end, to seek the assistance of the court in determining whether there is in fact a deprivation and obtaining authorisation for its continuance. So even if we have the scenario of a trust as the detaining authority, in our respectful submission, we wouldn't be complying with our positive obligations under Article 5 to be consenting to the trust detaining the child, using our PR, even though we're not the detaining authority. So whilst we have, as advocates, used that scenario to illustrate the procedural deficits of the process, plainly in a wider context, we would still be in difficulties providing the child with the requisite procedural protections if we were to consent.
So could you just tell me how far that argument goes? The child you've got a care order and child's got appendicitis, or worse, the child's got leukemia and going to have lengthy periods of hospital treatment. Does the local authority have to get authorisation as those being a deprivation of liberty in order to comply with Article 5?
There are some differences with whether or not the actions of the state are causing the detention. So, for example, a child having treatment for leukemia, if their illness and health meant that they couldn't themselves leave or seek to leave, or then there may be arguments around whether or not they are deprived of their liberty. There is, of course, in the Court of Protection, the Ferreira case, which deals with intensive care, where a person is receiving treatment, is perhaps comatose, and in a situation whereby they themselves cannot leave. And there's nothing that the state is doing to create that. So there may be individual circumstances where physical and medical treatment doesn't bring it into the scope of a deprivation of liberty. However, if a child was refusing medical treatment or seeking to leave or run out during the course of a cycle of chemotherapy or something of that nature, and therefore there would need to be potential measures to lock doors or to prevent the child leaving, security outside the door, that's likely to need to come to the court for authorisation. Indeed, I was involved in a case in front of Mrs Justice Ryder, as he then was, on that very point, a young man who wanted to leave during chemotherapy. Once the drip was in, there's very significant dangers for that, and there needed to be some consideration of the authorisation for potential for the use of force or to respect his wish and stop the chemotherapy. So there are complicated factual matters, but yes, potentially I accept that. There will be circumstances where the measures are not within Section 33, use of PR, but that's very specific to the facts. But have I sufficiently answered?
Yes, no,
those
that's
Great. So essentially then just dealing, if I may, with Article 5.4, and of course back to the HL judgment, there's a separate analysis by the court about measures then, the protective measures that need to be put in place once somebody's deprived of their liberty. And it was a necessary requirement, we submit, for the judge at first instance to look at the whole picture of Article 5, because the measures are separate, but they are overlapping. So, for example, looked after child reviews might lead to a situation where somebody is identified as being deprived of their liberty and the question of authorisation came up. And if the local authority could consent, that might be a forum in which that structure of decision-making takes place. That would not necessarily be sufficient, as Mr Justice Keane said in Re AB, but the looked after child review is also part of a scheme of reviews for a young person once they are deprived of their liberty. So there is overlapping even on the ground, but there is overlap in, as my Lord Justice Singh has pointed out, in relation to the overall imperatives of Article 5. In relation then to, forgive me, I pressed the, forgive me, I've given the wrong reference. So the issue of Article 5.4 starts in the judgment of Re HL at page
783.
Yes, sorry, 783, I apologise.
Paragraph 125.
Yes,
Yeah.
125. And essentially, a review, the ability to review the legality of your detention, the timescales as set out by my learned friend. What's key here is that under the arrangements approved by Mrs Justice Lieven, there would be no terms for deprivation of liberty and therefore no trigger to bring a matter to the court or to bring the matter back for review. And if one looks at the arguments that were considered that might, under domestic law in the UK, amount to sufficient protections under Article 5, and they start at 785, paragraph 133.
But we need to go to the court's assessment of paragraph 135, don't we?
Yes, essentially, the writ of habeas corpus and judicial review remedies, and we say they're not accessible to a child in this scenario, but even if they were, would not be anywhere near enough to amount to an inherent protection under Article
The fundamental point, and this echoes what the court had said in the early cases it refers to, like Ashingdane in the 1980s, is that although Article 5.4 refers to reviewing the legality of detention, that is not, the European understanding of legality is not the English understanding. We tend to take a very narrow view.
Yes.
Our judicial review law, for example, frequently stresses that the court is not entitled to enter into the merits of an assessment. Whereas the whole point of Article 5.4, according to Strasbourg, is that the court must be able to question the merits. And that means sometimes you probe with care scientific evidence, medical evidence, social workers' evidence. This is why I made the point earlier, that there's no judicial rubber stamp, even if everyone else thinks that this is a good idea. There's a purpose behind Article 5.4, which is quite independent of Article 5.1.
Yes. Well, my Lord puts it so much more beautifully than I've been paid for, so I'll adopt that if I may, and I agree, we agree, and that's the analysis that is set out, that, and also these remedies require an individual to establish that their circumstances are unlawful, and actually the very purpose of Article 5.4 is for the state to justify the detention of any individual, and to have that rigorously and with intellectually robustness to be analysed. Then if I may turn just to the last point, unless I can be of further assistance on whether the appeals allowed the order to be made.
Yeah.
If, as we have been proceeding, that we are proceeding on the basis of our consent to detain this young man, which takes it out of Article 5.4 upon the court making an order that the decision of Mrs Justice Lieven was wrong, we would be unlawfully detaining him from that point. And so we do invite the court today, or whenever the judgment is, or the decision is made, to authorise the detention for a short period, authorise the deprivation of liberty. We did send in, as observed by my lady, the updated social work evidence template and the care plan.
Yes.
The reason for that is we can't expect any court to make such a significant order without up-to-date
that was the right thing to do.
information. I'm grateful. The only difference is, to answer my Lord the President's question, in that relate to transition planning, because of course he's half a year older, and we have put in there a section to say that we're looking to transition him to the Court of Protection for 16, and that's a good reason, forgive me, I apologise, it's a good reason why it shouldn't really be a long order at this point, because there needs to be a robust look by the Guardian to question whether or not now is the right time to transition, or in line with other, to have that discussion. It's quite likely it will be, but one needs to look at where he is in his transition planning. So for those reasons, we don't disagree that it should be a short order, and not, as my learned friend is wedded to the 1st of March, it's when the matter can come back properly before a judge remitted, but it should be, if we may, early March, and not very long, about a month,
And
would be the maximum.
I think I saw you, Zabihi nodding that it should go back to the court in Bristol before a Section 9 judge.
Yeah, so, or however they allocate it, I don't have any difficulty with the matter going back to a judge of the division, or indeed Mrs Justice Lieven, because this court will set out what the right test is and it will be dealt with. But the court can allocate it, as they will with other dolls cases, in accordance with the need for the case to be heard on a particular week or particular day, and the judicial availability. We have no difficulty with that.
Good.
May I assist any further?
No, thank you very much.
I'm most grateful, thank you, my lady.
Yes, now, Miss Smith-Holland.
My lord, my lady, there is a short skeleton argument filed on behalf of the mother.
Yes?
You'll be aware from it that the mother supports Jay's appeal.
Yes.
For the reasons that have been set out, and subject to the better view of the court, I do not consider that there's anything that I could usefully add to what has been said and what is in those documents already relating to the grounds of appeal. Regarding, though, the point in relation to the order to be made in the event that the appeal is allowed, I just have 1 or 2 points to make in relation to that. My instructing solicitor and I have had the opportunity to speak again to the mother. She has been able to review the documentation that has been filed and is in agreement with the local authorities' plan and proposals. We therefore not only support the appeal, but we also support the application for a further order authorising the deprivation of Jay's liberty in the way that has been set out to you. So unless I can be of any further assistance.
I don't think so. That's very efficiently done. The fact that you've been short and no pressure, one hopes Miss Dixon will take a similar course, doesn't mean that we underestimate at all the role of the parents in all this. One only has to read about Jay and the years of really worrying behaviour that they've coped with, and then had to cooperate with the local authority in meeting his needs in another way, must be so emotionally draining and a constant focus for them. And the importance of them, and the fact that they are in agreement with all of this, is only to Jay's interests. It would be awful if everyone was at loggerheads about this. So the fact that your role, each of you in this hearing, has been relatively limited in time doesn't at all reflect my view of the importance that the parents play in the structure that is worrying about Jay and looking to provide for his needs.
My lord, yes, I'm very grateful. I know that both parents are watching this appeal on the live stream, and so those comments will have been heard by them.
Good. Thank you.
Thank you.
Ms Dixon.
My lords and lady, I take an even shorter position. You'll have had the chance to see the detailed skeleton argument that myself and Mr Goodwin have filed. And unless I can assist the court further, I don't propose to address the court in any detail. I'm very grateful on the parents' behalf for those observations.
Thank you. Thank you very much. So, Mr Keane, I think you're the first of the interveners.
Yes.
Yes.
Yes, my lord.
And we have your
So I appear
Kelly.
on behalf of Article 39 and Mind
Yes.
with my learned friend Ms Ariana Kelly and Ms Eleanor Layden. We're very grateful to the Court for permission to file written submissions and evidence and to make oral submissions. We propose to address 3 short points, if I may. The first is the key features of the evidence, and actually for that I'm going to hand over to Ms Kelly, if I may, in just 1 second. The second is the objective elements of confinement for purposes of Article 5. I will just also very slightly amplify that in terms of the rabbit hole of consent I think we went down a couple of minutes ago. I might just try and disentangle that, if I may. And then the third is the engagement of Article 8. So those are the 3 things we're going to cover. And as I say, if I may, hand over to Ms Kelly,
Yes.
who's going to address you on the written evidence point.
Good. Yes, Ms Kelly.
Thank you, my lord, the joint interveners of Article 39 in mind take no position on Jay's case, and we had filed 2 witness statements, one from Carolyn Willow of Article 39 and one from Alice Livermore, who are both behind me today, from Mind, which set out some of the broader context of the case and hopefully set out some useful information about the picture of children like Jay who may find themselves deprived of their liberty. I don't propose to go through those fully, but I would seek to highlight just briefly in relation to some of the evidence that we've filed around secure accommodation and Section 25. Again, this has already been covered by my Lord Ms Roper and Ms Kavanagh, so I don't plan to go through it in full. But if I could take the court to D112 and D113 of the core bundle.
Thank you. So this is in Ms Willow's. Yes.
We would just seek to emphasize, and this is set out in Ms Willow's evidence specifically, that there is, again, when looking for parliamentary intent in the Children Act, and particularly around children who are deprived of their liberty under the Children Act, under Section 25, there is no intention for a care order alone to authorize a deprivation of liberty for a child in secure accommodation. Ms Willow sets out in her evidence the very detailed process of procedural safeguards which are in place that go above and beyond the mere granting of a care order in that case. And the protections include the time limitations of a 3-month initial order and a 6-month subsequent order, the mandatory legal representation unless a child has understood their right to legal representation and is explicitly declining it, the lack of these being available for children under the age of 12, and is set out in detail in Ms Willow's evidence, the independent reviews which must take place. And in my respectful submission, Lord Malay, we would say that this sets out a very clear parliamentary intent that a care order alone is simply insufficient for any sort of deprivation of liberty, and Parliament did not intend to create that sort of situation. I would also emphasize in relation to the evidence filed by Mind, and this is particularly at D118 and 119 of our bundle, and again to emphasize that the impacts of this judgment in terms of a corporate parent being able to give consent to the deprivation of liberty of a child would go well beyond the very calm, benign sort of situation that's described in relation to Jay's case. It would apply to children in psychiatric detention. It would apply to children who are experiencing great distress as a result of their deprivation of liberty. The safeguards set out in the Mental Health Act, again, are set out by Ms. Livermore in her evidence. I won't rehearse all of them, but they are set out quite comprehensively at D118 and 119. But again, it does note that the Mental Health Act has no minimum age for detention under the Act. It has a very clear statutory framework for when a child can be detained under the Act, as with any person. And again, as was noted in relation to some of the points around Article 5.4, the Mental Health Act has extremely robust protections for quick access to a tribunal for those who are detained under the Act, and legal representation, which is a common element of both the Section 25 Children Act and under the Mental Health Act, is the speedy access to court and independent legal representation for the person. Again, like Section 25, the Mental Health Act offers a fixed duration of detention and regular reviews, and extensive rights of nearest relatives. Again, the upshot of the decision, if it stood, would be that children could be in psychiatric detentions at very high levels of detention with none of these rights, because they would simply not be recognized as being deprived of their liberty at all. Ms. Livermore's evidence also picks up the situation of children with learning disabilities and autism, where there's a current very strong push from the government to get these children out of psychiatric institutions and into other sorts of settings. And again, in the absence of any, Mental Health Act framework, the mere consent of a parent could put a child with a learning disability or autism into one of these situations. because it simply wouldn't be recognised as a detention under the Mental Health Act at all. Lord Millage, very briefly, because again, I don't seek to reverse the full evidence, but I think we would be remiss if we didn't highlight the evidence from Article 39 that looked to the extremely limited availability of appropriate secure accommodation, particularly for children with complex needs. This is detailed in Ms. Willow's evidence, and she notes the intense vulnerability of the children.
But I don't think you need to tell this court about that.
I suspect I don't. I know that many.
But the point is, it means that there are more young people who are coming through the inherent jurisdiction, and your submission presumably is that the approach under the inherent jurisdiction needs to be as robust as the statutory scheme, particularly for, I don't think it applies to Jay, but particularly for youngsters who would otherwise be in secure accommodation, but there's simply no bed for them in this secure estate.
My Lord clearly has the point. I don't mean to labor it. I would simply just refer the court to Ms. Willow's evidence, which sets out in detail some of the findings of the Nuffield Family Justice Observatory on this, and some of the data and background, and some of the comprehensive surveys that my Lord and others have provided in other judgments about the lack of secure accommodation for children.
Ms. Clement, no doubt, as she has in her skeleton, alert us to the fact that the bill going through Parliament at the moment looks to expand Section 25 to accommodation which isn't currently within the limited definition. But I'm sure that if it does expand it, it will have statutory requirements which mirror the need to comply with Article 5. Whether or not the local authority have a care order.
I'm grateful, my Lord. I would simply refer to the court to this, particularly at D111 and D112 of Ms. Willow's evidence, which sets out some of this particular data around this.
Yes, well, she gives the figures there, which is very helpful.
Yes.
Depressingly helpful.
Lord, very briefly, as a final point, we would again just emphasize that the dire position also extends to children in psychiatric detention, and particularly noting in Ms. Livermore's statement that care-experienced children are more likely to have had poor experiences in inpatient care, and they're more likely to have had multiple admissions to hospitals. So particularly for children on care orders, this is a particularly key issue. Unless I can be of assistance, I can.
Well, for my part, that was very helpful, very useful. Thank you.
Thank
yes,
you.
Mr. Rakim.
So as I said, the two other points. One was in relation to the objective element of confinement for purposes of Article 5, and then the other was going to be about Article 8. So just to emphasise, mine and Article 39 are neutral as to whether the court should authorise the arrangements for Jay. We're neutral on that. But we do invite the court to confirm very clearly that the arrangements for him that were described in the judgment of Mrs Justice Lieven at paragraph 9 do constitute a confinement. We would also we'd urge upon the court to make clear that this is because they are just not normal arrangements for a child of Jay's age. And in doing that, you would be applying the test set out in Cheshire West by Lady Hale, by Lord Kerr at paragraph 79. For your reference, that's page 75 of the authorities bundle, but I hope you don't mind if I don't take you to that now. And then again endorsed in Read D by Lady Hale at paragraph 40. That's authorities bundle page 101. So the simple fact being, the arrangements for Jay, the confinement, go beyond those that we would consider normal as a society for a child of Jay's age.
What was the paragraph for Baroness Hale?
In Read D, it's paragraph 40.
40.
And she refers back to the observations of
The
Lord
point
Kerr.
being made is that it's wrong to compare the arrangements as being normal for a child who has got Jay's problems. That's it. Right.
Exactly, my lord. One reason just to labour this, and I would say it's quite odd, if I may, that Read D, which is binding Supreme Court authority, certainly from 16 plus, does not seem to get referred to very much in quite a few of the cases involving under 16s. In terms of the approach to the idea of what confinement looks like. One of the other reasons for emphasising it is you'll be very well aware that the Supreme Court handed down judgment last week in the case of a father versus Worcestershire County Council, which was an unusual decision for all sorts of reasons, not least of which was it is essentially entirely one-sided. And you could possibly read some of the observations in that case, in particular at paragraph 38, as suggesting that you only start getting troubled about the idea of the objective element of confinement if the circumstances are extreme. And to the extent, I have to say with respect, I don't think that's what the Supreme Court was seeking to say, but to the extent that there's any mismatch between is the confinement, are these arrangements what we would expect for a child of this age, and the observations of the Supreme Court last week, mind and Article 39 would simply say both Reedy and Cheshire West were, as it were, very hard-fought cases with full arguments on both sides. The observations of the Supreme Court last week in Worcestershire were not observations made after full argument.
So you want us to say what we think the Supreme Court intended to mean?
Or simply say, as the Supreme Court said very clearly in their judgment, nothing we say here is intended to have any effect in relation to the appeal in Re J, which they were very aware was being heard.
But that's very helpful.
Yep.
I need to look at that. Thank you.
Just in relation to consent, it may assist if I set out our understanding of how this plays out, and I don't want to repeat things that have been said previously. But essentially what one's looking for, or what one is saying is, the local authority can never consent to confinement, because otherwise they're just marking their own homework, and everybody seems to be in agreement about that. If we're talking about natural persons with parental responsibility, I'm extremely grateful to Ms Clement for finally coming up with a phrase which no one else could think of one, she nailed it. In relation to under 16s, that is very squarely not before you. Article 39 and Mind would urge upon the court not to give any suggestion that that issue is resolved at an appellate level in favour of the idea that parents could consent, natural parents could consent. It's simply unresolved. In relation to 16 plus, it is crystal clear from Re D that a natural person with parental responsibility simply cannot consent. And that's irrespective of whether the child lacks mental capacity to make decisions to consent to their confinement. That was the entire point in Re D. So whatever role PR plays before 16, it disappears from 16 plus. And then in relation to the observations being made in T about consent, that wasn't anything to do with the consent of a local authority. That was all to do with the consent of the child themselves. And in my submission, in any case where the state is seeking to confine, and it's super important to be clear, the sort of confinement we're talking about here is benign, but we mustn't allow ourselves to get misled into therefore thinking we have to look at it less seriously. And my Lord Justice Singh is very well aware of that, not least from Bournemouth. And we're all aware of that from the case law. So that we need to be very careful about not relying too heavily on a child's consent, but certainly there's case law which suggests a competent, so pre-16, when Gaelic competence might be in play, a competent child could consent to some circumstances, and a capacitous 16 or 17-year-old child could consent. But if Section 25 is in play, then whether or not the child is seeking to consent is a factor the court is taking into account in deciding whether or not to authorise. It's not a factor which is saying this child is or is not deprived of their liberty, is my understanding of otherwise we do go down some quite serious rabbit holes. But for today's purposes, the most important point is a local authority simply cannot consent, because otherwise it is, we just go full circle.
Just so that I'm sure that I've understood you, when you say it's unresolved at appellate level that parents can consent to confinement under the age of 16, that's a reference to the fact it was Mr Justice Keane who held that they could.
Yes.
But that, although that's been nodded at with respect at appellate level, no one's actually decided it.
No, and I mean, just to be absolutely clear, the official solicitor actually who did instruct me in Re D when he turned 16, before Mr Justice Keane in round 2, did in fact argue Mr Justice Keane had got it wrong, but at a point when the official solicitor wasn't acting for him, it was the children's guardian, and then it didn't go any further on appeal. We have Lady Hale saying, I can see the logic applying, but the Supreme Court being very clear.
And didn't, and again, it's Mrs Justice Lieven
Yes.
in the Lincolnshire case,
Yep.
who also concluded,
Yes.
and a number of the submissions that we've got are that we ought to endorse that.
And I would...
But you would say it's not a live issue.
Absolutely, my lord. And the other point I would make is, these are cases, in particular the TGA case, where no party sought strenuously to argue that there wasn't a deprivation of liberty. So there simply wasn't a full argument, nor indeed was there, putting it very crudely, any interest on any party on appealing. So they are foundations which are not rock solid upon which to build an idea that there is a body of case law which suggests. And obviously you will have seen from our submissions, written submissions, at one level we felt it might have been helpful for this court to resolve this issue now, but we absolutely are not inviting you to, because it's not a live issue. And I think the last time I was in a court with this many barristers was Re X, where it was ultimately decided by the Court of Appeal that Sir James Mumby had been deciding an issue which wasn't live, and it was deeply problematic. So we're definitely not inviting you to determine a question which isn't live. The short point is, what we're inviting you to do is not to make it sound as if the body of first instance case law is, as it were, now got tacit endorsement, if that makes sense, my lord.
Thank you.
The other point I make is a short one. It's about Article 8, which is engaged very often in these cases. Because children subject to confinement are frequently not just confined in the sense of physical liberty, but they've got heavy-duty restrictions on access to things like internet and things like social media. Mr. Justice MacDonald, in the Manchester case that we referred to in our submissions, and that Supplementary Authorities Bundle tab 17, he makes very clear that restrictions on internet, on social media, they're all interferences with Article 8, not Article 5, because Article 5 is about physical liberty. But what we do invite the court to note is the extent, well, two things. The first is, A, frequently it's really not very possible to distinguish quite so neatly the physical liberty from the total package which is going to supervision and control. And the second is to remind the court that we don't just have procedural protections for Article 5, which are explicit, we've got procedural protections around Article 8. They're implicit. And the reference for that, if you need one, is Lashin and Russia, which is in the Supplementary Authorities Bundle at pages 670 to 671. And the short point we want the court to consider is that if ultimately it emerges that local authorities, given this is a case where we anticipate the Court of Appeal is going to, as it were, give a course correction in terms of what local authorities can consent to, it is also to remind people that if local authorities are seeking to discharge their corporate parental responsibility in relation to interferences with Article 8, that they properly recognise that is a serious interference, there needs to be proper consideration of necessity and proportionality, and there needs to be proper recognition of the interests of the child. What we're definitely not inviting you to do, because it would be inappropriate for us to do so, is to try and to set down a set of frameworks, but it is simply, if there's a course correction going on at appellate level, which Article 39 in mind would say is in some ways well overdue, that it's to remind the court that Article 8 is almost always sitting alongside.
Yeah.
My lords, my lady, unless there's anything else I can assist you with, those were our submissions.
No, very helpful.
Thank you.
Yes, Mr. Broach.
My lords, my lady, I appear for the Children's Commissioner for England.
Yes.
The second intervener, assisted by my own friends, Mr. Thorold and Mr. Carvalho. my Lords, my Lady, you may well be aware that the post of the Children's Commissioner was initially created under the Children Act 2004. Her primary function, under Section 2 of that Act, is to promote and protect the rights of children in England. And her role was strengthened by the Children and Families Act 2014. She now has special responsibility for the rights of children who are in or leaving care.
Yes.
That, of course, is why I'm here, my Lord, because of the Commissioner's concern about the implications of the judge's judgment. The Commissioner is grateful for the grant of permission to intervene in this appeal. Like the other parties and interveners, she invites the Court to disapprove the approach of the judge below on the central question of whether local authorities can give consent to confining arrangements, if we use that shorthand. We agree, my Lords, my Lady, with the charity interveners that this Court ought not to say anything about the position of natural persons with parental responsibility, whether by reference to the Lincolnshire judgment or otherwise. We also agree with the point made by the Secretary of State in her submissions that there is no domestic or Strasbourg authority in support of the approach that the judge took below on the question that does arise about the potential for local authorities to give consent. The Commissioner has filed written submissions, and the Court, I hope, has that in a supplementary bundle.
We do.
I'm grateful for that reassurance. That was my housekeeping point.
We've read them.
I'm even more grateful. They're supported by a short statement from Beatrice Longmore, from the Commissioner's office,
Yes.
and a rather longer report from the office, which features the voices of children with complex needs who are deprived
Yes.
of
Well, I know that I meet the Commissioner regularly.
Yes, my Lord.
And I know she, along with all the topics that she is concerned with, takes a particular interest in these issues.
She certainly does, my Lord. And of course, the Court may well be aware that the Commissioner intervened in Re-T.
Yes.
And sought to emphasise the point that was made by my Lord, Lord Justice Singh, in relation to the need to apply the terms of Article 51D and E carefully in every case. What I would seek to do orally, my Lord, my Lady, is develop the two key points in the written submissions. Firstly, focusing on the practical importance of the Court's supervision.
And purely in terms of time management,
Yes,
do you anticipate completing that before the short adjournment?
I do, my Lord, because that's the time I have. Oh no, my Lord, I do have a little more time than that. No, I would be grateful for the 20 minutes, so
Very
probably
good.
not quite.
And so, Miss Clement, you presumably will need a bit of time, and so there was a time early this morning when I thought we might conclude by the short adjournment. But if we hear your submissions, even if they go slightly beyond 1 o'clock,
I'm very grateful.
then we'll come back for the Secretary of State's after that.
I will strictly confine myself to 20 minutes
Well, I won't
as an
interrupt.
intervener, of course. We don't want to detain the Court. But I do wish to develop, if I may, the 2 points in our written submissions. And as was canvassed by my own friend at the outset, we do focus on the practical importance of the Court's supervision of these cases for children and the vital role of the Court in ensuring that the voices of children are heard in this process. So the overarching submission we make is that the judge erred in principle in finding that court oversight of care arrangements can serve no practical function, in particular in allegedly obvious cases where all agree that the arrangements are in the child's best interest. That's really paragraph 20 of the judgment below. And we agree here with the analogy posited by my Lord Justice Singh in relation to the position in HL. When one shines the Article 5 light on these issues, different answers might arise. And we do demur strongly from the judge's finding in paragraph 16 that these cases have anything to do with defending a potential damages claim. That is not why we say they are important. The written submissions of paragraph 8, which are in page 23 of your supplementary bundle, set out why we say the practical importance of the court's supervision is not only confined to those cases where there may be a real dispute as to whether the child needs to be confined or objectively deprived of liberty. That scrutiny also ensures that restrictions on the child's liberty, which might go beyond those that their age cohort would routinely experience, remain justified, both in terms of their intensity and their duration. And we cite from what an older child who spoke to the Commissioner told us, the Commissioner's researcher, I think it was okay to have the restrictions, but not for as long as it was. It just felt like it got more and more annoying as time went on, because I was like, I'm okay, I can do this. So we say, paragraphs 10 and 11 of the submissions.
Well, it's that also, my eyes gone to the next part of the quote in paragraph 9. Nobody asks how I feel, nobody asks what I want.
That's our second point, absolutely.
Oh, sorry.
No, not at all, my lord. I'm grateful your lordship's ahead of me.
Having heard that one of the advantages of being president is that I sit at first instance.
Of course.
And I have at any one time a number of these dolls cases, and I go and visit
Yes.
the youngsters in their accommodation, and for them to have a guardian and a social worker visiting them, and occasionally the judge,
Yes.
either visiting them or hearing them on screen if they want to, is very important.
My lord, quite.
It's not overplaying it, but it's potentially therapeutic.
Yes.
But it's certainly, in terms of their rights, very important, even though they may not have capacity to consent or not to what goes on.
Absolutely, my lord. It's a vital forum for the voice of the child to be heard, and that is what we say fundamentally was lost by the judge. And the much narrower focus on the formal approval and thereby extinguishing any kind of damages claim, we say it misses the point entirely with respect. That the voice of the child being heard in the process is of far greater importance. We also say, though, that there is a substantive benefit to the child, other than simply having their voice heard, as important as that is, which is that the prospect of court proceedings and the ongoing supervision of the court does tend to encourage local authorities to focus on the location, the nature, the intensity of the restrictions applied, and potentially reduce or ameliorate them. And this then picks up my Lord Justice Singh's point, as canvassed with my own friend Ms Roper, that restrictions must be necessary and proportionate to the risk to avoid the breach of Article 5. There is some discussion of this in Re T, paragraph 155, Main Authorities, tab 7, page 184, where it said the court will not give the local authority authorisation that they seek without considerable exploration of the circumstances to ensure that the proposal is appropriate. And that word appropriate reflects the Strasbourg case law, the recent Grand Chamber decisions, in two cases which have been sent to the court, and I apologise, hard copies are on their way. They should be here by the time we resume. Blokhin and Russia is the first.
Blokhin?
Blokhin, Blokhin, my lord. And Rumen and Belgium. And perhaps, if I may, I'll return to those when we have the hard copies to hand after the short adjournment. In essence, they highlight that any justification under Article 51D or 51E must include a focus on whether the arrangements being made are appropriate. The court also has two case studies in our written submissions, paragraphs 12 and 13. Children known to the Commissioner, who we refer to as Christopher and Meiser, whose circumstances were actively improved following the involvement of the court on an application for authorisation of the Deprivation of Liberty. And that's picked up in the research report at page 9, at page 44 of your supplemental bundle, where there's a summary of the researchers' findings, which includes that children were positive about their current care team and setting, i.e. once there had been an authorisation process, but most had previous bad experiences of unregistered or poor quality placements and staff who did not meet their needs. Ms Longmore notes, my lords, my lady, at paragraph 11 of her statement, that in fact, even on the approach of the judge, court authorisation of the Deprivation of Liberty for Christopher and Meiser would still be required unless a natural person with parental responsibility consented. Because Christopher wasn't the subject of a care order, he was accommodated under section 20 of the Children Act. And the local authority didn't have parental responsibility for Meiser at the relevant time. And we say there's no rational basis for a distinction in the approach between whether or not the local authority happens to have parental responsibility at the relevant time. We would say that children who are subject to care orders are even less likely to have natural persons with parental responsibility who are willing and able to challenge the appropriateness of the care arrangements. And so for the cohort we're concerned with today, it's even more important that the court considers those arrangements. We take issue, my lords, my lady, paragraph 14 of the submissions, with the judge's view that deprivation of liberty for a child can ever be a situation other than of great magnitude. Even if Jay's case is an obvious one, we of course make no submissions on Jay's facts. Our submission is that the level of restriction required for a child objectively to be deprived of their liberty in circumstances where this is imputable to the state means this will always be a matter of great magnitude.
But on my reading, the judge got into considering the phrase of great magnitude because she was following the line of cases about vaccination and
That's
medical
right.
treatment, which I think you're all unified in saying that was the wrong route.
Quite
That there simply wasn't the capacity for the local authority to consent because this is an Article 5.
That's right, my lord. It's an error of principle.
I'm very happy that you've made these submissions, but I don't think they're actually relevant to the...
I need to say no more about that, my lord, because that is precisely the point you make. And it comes back to, my lord, Justice Singh's Article 5 lens, that different considerations apply in those circumstances.
May I just ask one question about that? In paragraph 27 of the judgment, the judge quoted what she herself had said in the Lincolnshire case.
Yes, my lord.
And I only ask this because we may have to say something in our judgments about Lincolnshire. We may not, but I just wanted to ask for your help on this. The passage she cites really makes the same point that you've just been dealing with. So to that extent, at least, can it be said that she was also wrong in the Lincolnshire case?
My lord, yes, respectfully. The self-denying audience we invite the court to adopt on Lincolnshire is on the question of whether natural persons with parental responsibility can consent. To the extent that the judge has relied on Lincolnshire to buttress the finding that deprivation of liberty can be treated in the same way as important medical decisions or other decisions that have an important impact on the life of the child, we do say that's wrong, we positively say that's wrong, because it ignores, respectfully, the very important case law on the specific requirements of Article 5. The need for a rigorous focus on the language of Articles 5.1d and E in these kinds of cases, and the particular requirements of Article 5.4, which canvassed earlier as well. So the short answer to why deprivation of liberty decisions should be treated differently from other important decisions is it's only the former category that engage Article 5. My lords, my lady, the second key issue on which the Commissioner seeks to assist the Court is the importance of children's voices being heard, which of course we began to canvass at paragraph 16 of our submissions onwards. And we say that the research shows that where children's voices are heard, this can both improve the child's response to their care arrangements, but also reduce the period of time they need to be objectively deprived of their liberty. And one of the children interviewed put it extremely pithily: the fact that I had no say, it still enrages me to this day. And understandably, a child who feels enraged by the lack of an opportunity to have a say is much less likely to be working with those who are responsible for their care. So we do say that the court process provides a vital independent platform for the child's voice to be heard. Of course, the Commissioner's view is that the current system isn't perfect. The Lordship has the evidence on that, paragraph 20 of Ms Longmore. Many children feel that even the current system provides limited opportunities, but whether the current system can be improved isn't the question for the court. That's a matter for my own friend Ms Clement, Secretary of State, and Parliament. What matters is that the best available platform is provided for judicial scrutiny of highly restrictive care arrangements and for children's voices to be heard. And we do rely on Article 7.3 of the CRPD, the Convention on the Rights of Persons with Disabilities here, which is in the supplementary authorities at 776, on the importance of disabled children like Jay being able to express their views freely on all matters that affect them and their views being given due weight. And that, of course, reflects the general obligation for all children in Article 3 of the Children's Convention. So we do strongly rely for our second point on the importance of children's voices being heard, as your Lordship.
Yes, but that clearly I accept that, and it's not what this case is. This case is about the legality and the advantages of approach in law, but on the ground, not only child having a say, but also knowing there's a review date. But some of these young people, if they can focus on that, and they want to get out of the doles, or whatever it might be, or have the restrictions reduced to a degree, the fact that there's a date that they can work to is really very important.
That's right.
There may be dates with an ordinary review within the local authority process, but it's a wholly different order, I suspect, in the young person's mind, to the judge and the guardian coming together on a date.
Respectfully, my lord,
So
yes.
it's not why Article 5 says what it says, it's not what the case law says, but it's on the ground.
But
These
respectfully,
are
my lord,
very important.
we would say it is in part why Article 5 in the case law says.
Yes,
what it
yes,
says.
but
In
it's
fact,
not
the judge has misunderstood the policy underpinnings of these safeguards. Your Lordship has the submissions on that. My lords, I note the time. I do now have the cases, the two Strasbourg cases, but perhaps what I could do is hand those up and then deal with them after the short adjournment, or hand them up during the short adjournment, if that's good.
Do we do that? Yes.
Or I could take 5 more minutes now in your Lordship's hand.
I think it is more sensible to do the practical task of handing it round, which always takes a minute or two
Yes.
while we're not in the room.
I agree, my lord. Respectfully.
It would help entirely selfishly me, knowing we've got a bit of time, if we didn't come back till 2:10. Is that
Of course, ma'am.
convenient? So we'll rise now until 2:10, in the firm expectation of being finished before the next adjournment.
All those in favour?